Hey, 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 all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, you shall be heard. State of the Commonwealth of Massachusetts, court is open, please be seated.
Thank you and good afternoon. So today, we're hearing only one case this afternoon. It's been rescheduled from the month of December. The case number is 2022-1084, City of Marlborough versus Dorothy E. Santella. Before I ask you to begin your argument, I'm going to introduce the panel to you. To my right is Justice Peter Rubin. To my left is Justice Paul Smyth. And my name is Ariane Vuono. I'll remind you that you each have 15 minutes to present your argument, and there is no rebuttal in the appeals court. I will let you know that we've read everything that you've submitted to us thus far, including additional cases, and so you can get right to your most salient points as soon as you can. All right? So, you may begin.
Good afternoon, Chief Justices. If it please the court, my name is Judith George Driscoll, pro se appellant. I am here today to appeal to the court on the issues in the lower court, primarily focused on constitutional violations and errors of law. I'd like to first address my argument to the constitutional issues.
Can I ask you a question about that? And I should say, I know being pro se is very difficult in a court, and it may be intimidating, and we're going to do our best to hear what you have to say and not intimidate you, so that to minimize whatever difficulty you might have. So let me ask you this. If we agree with you that Tyler means the city can no longer keep the whole property, they have to either pay you or pay the owner compensation for any amount above the amount of tax due, or sell the property and take only the amount of the tax and then pay the remainder to the owner. If we were to say that that is the rule, is that the end of the case? Are you then satisfied with whatever outcome? You know, we would send it back to the lower court and say, you can't just do a taking, you have to have an order to deal with whatever's going to happen to make sure that the owners of the property get compensated. Would that eliminate the need, leaving aside parcel E, we'll talk about parcel E in a minute, but with respect to parcel C and D, would you have any other complaints?
Well, I understand what you're saying, Your Honor, and I thank you. I guess under Tyler was a little bit distinguished from my case in the fact that Miss Tyler, her property was sold, and she went and filed her complaint seeking the surplus from the city, or the town. In my case, there hasn't been a sale yet. So my position here is focused narrowly on the court's ruling under the takings clause that the government cannot just take your property and not pay you for it, and it goes back to the time of the taking. I had found an additional case that I didn't get an opportunity to brief because of its late coming on. It's a 2023 case. It's Supreme Court. It's Nick versus the Township of Scott. And the court in that case said that the takings claim accrues when the government takes the property. So basically, what I'm asking for this court is to issue an order to vacate the judgment in the lower court, to remand it, and to allow us to have a hearing, an evidentiary hearing, because the second part of our issue here before this court is not just the taking and the taking of the property for more than the amount of the debt due. It's that we dispute the amount of the debt that they have claimed because we have paid the taxes. And in fact, in 2009, when they filed the complaint with the land court, at that point in time, we had proof, but was never able to present it to the court, that the city actually owed us a credit. It wasn't that we owed the taxes, they owed us a credit for
Okay,
overpayment.
well, I want to leave aside the amount of the taxes for the moment and still figure out the sort of bulk of the issue, because if the property is as valuable as you say, even at their amount, the taxes are a quarter of the value or something. It's not, I mean, that's a lot of money, obviously, and we can talk about that. There's things that the court said and that the city has said about whether you did or didn't pay more and whether there needs to be an evidentiary hearing. But what I'm asking, I think, is this. As this currently stands, if there was no Tyler and you wanted to redeem the property, you would have to come up with cash to pay the debt. And I guess you or your husband was given 60 days, asked for 90 more, and that was denied. But however long you get, you have to come up with the cash. And then if you pay the cash, then whoever owned the property continues to own the property, and the city is satisfied. But under Tyler, you don't have to come up with any cash because the city, and of course I'll ask counsel for the city if this is what they would want to do, but the city could still take the property and either sell it, you know, hold an auction, market it, whatever, get the highest value for it, keep the taxes and give you or whoever owns the property the rest. And I'm asking, is there a reason you would prefer to have time to, I don't know if we can do this even, but additional time to actually come up with cash and pay? Or will you be equally satisfied with getting whatever the remaining value of the property is after it's sold, to whatever extent you or your husband is an owner of the property?
I understand what you're saying, Your Honor. Our position is we don't want to leave the house. I've invested over 47 years into the property, my husband and I. We have over 900,000, it's in my exhibits, of paid into, equity paid in. The first and foremost issue here, over and above Tyler, even if Tyler hadn't been ruled on back then, is basically the city has caused us irreparable harm because back in 2009, when they filed the complaint and I went into court and asked the court to redeem the property, the land court said, no, you're not a party of interest, you can't redeem. And at that point in time, the tax debt was a mere $6,000. That's what was recorded by the city in the land court. And the value of the property, not even the market value, was over $500,000. So my argument back then was, I was ready, willing, and able to pay the $6,000, take it out of land court.
Okay, but now we're not in 2009, and the court has said, and obviously we have to look at these numbers, but the court has said it's $200 and something thousand now. And they're adding interest to it. We have to figure out what's right and wrong about that. But they say it's this much, and so my question is, if it's that much, are you going to come up with cash to pay it? Or would it be just as good for you to have the city sell the house, if they're willing to do that, which I have no idea, and give you or whoever the owners are the value in money above the tax amount? And I don't want to make this more complicated, but we do have a representation from the estate, I gather. I don't know why it hasn't been distributed yet, but maybe it's because of the litigation. The estate says, the probate court says the estate owns half or two-thirds, some portion of the property, and the estate says, we're not going to go along with mortgaging this, which may make it impossible. One person shows up and says, you can have a third of the house. Banks don't want a third of the house for collateral. They tend to want the whole thing, right?
Yes, Your Honor. But with all due respect, Your Honor, that claim by the estate is patently false. First and foremost, they've been deliberately
The probate and
misleading.
family court in 2021 said that it is, I don't remember what the right phrase is, tenancy in common. Tenancy in common between Joseph Driscoll and the estate. That's how I understand it. That's not before us at all. That's done.
Right, but what they've done is taken Judge McSweeney's order out of context and mischaracterized it, because nowhere on that order does it say the divided shares. As a matter of fact, Judge McSweeney went through a lot of trouble at the end of the equity complaint in 2014, in that there were companion cases, and he said he wasn't going to make a decision on the shares of the parties because he hadn't seen any evidence.
Okay, but if you can't come up with the tax payment in a reasonable amount of time, then there will be a tax taking, I assume, and the tax taking will take the property. You'll be entitled to the value above the tax, but they will take the property. They'll either sell it or use it, and they will have to pay the owners, whoever that is, whether it's you or the estate or whatever. And I'm just trying to figure out whether that changes your perspective on what you want to have happen here.
Well, I believe, Your Honor, that I have the availability to pay the taxes, even though I'm disputing the amount that they're claiming, because the value of the property was recently appraised, I had it recently appraised, is $1 million.
But how will you mortgage a house when there's a judgment that says someone else owns a part of it?
That's the problem that the city created, and that's why I need for the court to bring it back to.
Well, we can't undo the probate court judgment. It's not on appeal here.
No, I'm asking for the court to remand the case so I can bring the issue back to the court and have a hearing. We were denied a hearing on that issue, and it was deliberate. That deed was valid. The chain of title is there to prove that it was valid. It was just arbitrarily removed from us. And you're right.
Which deed precisely are you referring to?
The Truetta, the issue with Truetta 108.
But that's only a parcel E, if I'm
Right.
right. That has nothing to do with parcels C and D, which I'm assuming those are the parcels that were worth about $1 million in your view.
No, actually.
The whole thing,
Yeah,
C, D, and E.
Right, but actually, D could easily be separated out under 22A, because it's actually a wooded parcel across from the driveway, and the key lots are C and E, because the house sits on both of those parcels. And that's why I honestly believe it was part of a scheme, if you will, to deprive us of redeeming the property, because, as the attorney told the court, there's no bank that's going to give the Driscolls a loan or a mortgage when the city owns half the house. And the city owns half the house because the court erroneously ruled contrary to 155.
Yes, but the estate also said, we will not consent to an encumbrance on the property. And I don't know how you can get a mortgage without all the owners, and you may contest that they're an owner, but as of right now, there's a judgment, and you'll need the money, you needed the money at the time quickly. You can't go into a bank and say, well, we're litigating about it, we're very confident we're going to win. They're going to say, like, well, if you win, you can come in and we'll talk about giving you some money.
I understand what you're saying, but I also have other alternates where I have access to money.
To the full $228,000?
Yes, I believe so. It's a separate
Can I ask
lawsuit.
this? There was a $367 tax bill, I think, on Lot E. Why haven't you paid it?
I did pay it, Your Honor, and it's in the exhibits. I even have the canceled checks. The problem is the city of Marlborough, the collector, and I wrote that in my brief, that he never discharged it. And they even wrote it on the money order. It said tax title 108E for the parcel, whatever it was. But they, contrary to the law, they never filed the redemption certificate after I paid the tax lien in 2006. I paid it all. And at the time they filed, this was the argument, at the time they filed that the new tax taking in 2009, all the taxes were paid. As a matter of fact, 2 years prior to that, in 2007, the city issued a redemption certificate for the parcels, but unfortunately, they didn't do it for that third parcel, 108E. So that debt never got cleared off the books, even though I have the checks to prove I paid it.
But that
that's
was
not
brought,
on
but
me.
that was brought before the judge in the land court, correct?
No, we never got to, basically, there were never any hearings. That's the problem and my issue here. We were denied that due process, and that's why I want the court to.
But this is not the first time, just to be sure, that you've made this argument, correct? That you actually paid the taxes and that the collector had not discharged the lien. This is not the first time that you've
No,
put-
we
right.
brought it up in writing to the land court, but the land court, because the land court struck our appearance and all of the pleadings, I mean, how can that be determined due
Well,
process?
that's because he determined, or she determined that he struck the pleadings for the person who was a non-owner.
Right, but under Talaj Williams, Chief Justice Gantz citing the United Trust in Linfield, he said that there are many available varieties of claims to the property that would allow a person to redeem. And that is mine. That was my case. I had an equity interest. I had a list pendants. I paid the mortgages. I had actually what could be considered under law, under 6060, a tax lien because I paid all the taxes. So I had enough, I believe, to tell the court that I had a viable interest. I was the real party in interest at that time in 2009.
Okay.
And I was denied.
All right. Now, as I said initially, unfortunately, you have 15 minutes to make your argument, but of
I'm
course,
all
we
over.
look at your brief and your reply brief. So your time is up, but we are entitled to ask more questions if we want to.
Sure.
So I want to see if you have any more questions from that. Okay, so we don't have any more questions, and so
Okay.
what happens is you rest on your brief. None of the arguments that you've made in the brief are waived. We still look at them anyway, okay?
Thank you. Thank you, Your Honors. I appreciate the time. I left my pen.
Go right ahead.
Sorry, thank you.
Good afternoon. May it please the court, my name is Peter Brown. I represent the appellee, the city of Marlborough, and I have represented the city of Marlborough through the inception of this litigation going back to 2009 over the past 15 years. Despite the 15 years, and there are a whole lot being contained in the briefs and the argument and the history, in our view, the case before you is quite simple. Real estate taxes were owed, real estate taxes were not paid, and they remained unpaid despite a substantial amount of time to go and get that resolved.
What do you say about Tyler?
So, Your Honor, Tyler, for purposes of our briefs, Tyler was decided.
Yes,
after-
but it's the law now, so we have to apply it.
Agreed, Your Honor. So the city's view is essentially as your question was laid out. The way we view Tyler is Tyler overruled Kelly v. Boston, which interpreted that under Chapter 60, a municipality would retain all the surplus and would not have any responsibility to account to a former owner. So the city of Marlborough here believes they have ownership of parcel C and D and E. Their plan would be to go and do a public auction of this property, and when everything is sold, they would do a valuation of C and D, do an accounting to the former owners, which in the case of C and D would be Mr. Driscoll and the estate of Dorothy Santella, in the case of parcel E would be Truetta Corporation, and any surplus that would be generated would be remitted to them, and that would be compliance with Tyler. We do not believe Tyler in any way vitiates the court's authority to have issued a final judgment and to have granted title to the property.
Let me ask you this. I'm not sure I completely agree with that, but I see your ultimate point. Ultimately, that sounds like what has to happen, I would think, if you don't want to use the property and find some cash. You'd have to sell it. The estate is a part owner, you say. They have not objected to the tax taking of their property?
Correct,
I
Your
don't understand that.
So, to understand this litigation is to take in the full 15, 20 years of litigation history of not just the city and Mrs. Driscoll, but of Mrs. Driscoll, Mr. Driscoll, and the family.
Sure.
Tortured litigation. They have you have two appellate cases, the Judge McSweeney judgment, and then you have the Middlesex judgment afterwards. What the family did is, and they've put it in the papers, which is in the record, and they've said, we're done with this litigation war of attrition. We can't spend any more hundreds of thousands of dollars. It's crazy that that Judith and Joseph are still in the house, not paying taxes, not paying rent. The probate case has gone on for 10 years. It's going to go on for another 25 years. And they've said, go and just foreclose on the property. When you put it up for auction, potentially
Okay,
we'll
so
go
I
and
gather
buy it.
their position is something like, we'd rather have them out of the house than in the house. All right. So next, the E property. Who are the defendants in that suit?
Truetta Corporation.
Does that exist?
It is a dissolved entity.
Did anyone show up?
No one showed up, Your Honor.
Are
They
you
were
allowed to
defaulted.
foreclose on a property without finding who actually owns it? And
There was a fine, so Your Honor, under Chapter 60, the record owner was Truetta Corporation.
It is a dissolved corporation.
Correct. So it was a corporation that was recognized as dissolved. And then the city was under an obligation in order of the Chapter 60 to comply with constitutional law to go and do due diligence with respect to who may have had an interest in Truetta Corporation. And so we did that research, and we provided to the court our due diligence, which was reviewed by the ex parte justice and accepted. And then notice by publication was issued as to the corporation.
Did you
as-
find that the successors were this Ricci and this other person?
They were served through publication.
Through publication. So you don't know where they are and you haven't sent them mail?
As part of the court case, they would have been sent publication, and then the court requires service by certified mail and then by deputy
If a
sheriff.
stranger walks into your office with a check for $367, I'm sure the interest has made it more than that now, but walks in with a check for $367 and says, here's the taxes, what happens to that property?
If taxes are paid and the municipality assumes that the person tendering it has an interest in the property.
Well, no. Person with no interest in the property just says, I don't like big government, you town of Marlborough taking people's property, here's $367. It's the taxes. Your debt is paid. I'm an officious intermeddler, but
I think a municipality has one of two options in that hypothetical, Justice Rubin. I think, one, they can certainly take the money, would apply it, and then they would redeem the tax taking. I think under Chapter 60, they would have the authority, if they so chose, to decline the right of redemption to someone who does not have an interest in the property. I think that
And what's the
discretionary
alternative?
choice belongs to the municipality. I'm
what's the
sorry.
alternative? You said you had two alternatives. One was to
Take, and the other one would be to reject because that person.
reject the $367. Now, that made sense before Tyler, because, ooh, look, $367, but we get this whole lot. It has an addition to a house on it. Awesome. But under Tyler, you can't do that anymore. You're going to get $367 for that property, and the rest, which could be a substantial amount of money, that's an accounting question or an appraisal question or something, the rest goes to whom?
So in the case of,
E.
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 It
So
goes
what
to-
would happen with respect to E
Yeah.
is that we would go and send notice, just as we did to Truetta Corporation. I assume we would not get
Well, since it expired in 1964, I don't think they're going to respond, but all right.
understood. And what's
Just so we can figure this out, so no one has responded, even though the city did what was supposed to do under the law, did publication, blah, blah, blah. No one's there, so in practicality, what happens?
Well, this situation is particularly difficult because of, you're going to sell the property, the intention would be to sell the property as one united interest. And then you would have to value C and D and then separately
Well,
go.
is it abandoned? Is the city at some point going to consider E abandoned because you cannot find anyone who is a successor to this corporation?
The city, I think, could consider any surplus funds that would be available to E abandoned and either
And then keep
receive it to the state or to the municipality as to the valuation of E. But without question, as to C and D, the owners of that property, the day before the city foreclosed on C and D, were Joseph Driscoll and the estate of Dorothy Santella. You can argue about whether Joseph had a third, or he had a half, or two-thirds.
And if you do,
but those were
and if
theirs.
your tax taking is either affirmed as it is, or we send it back to have the judge's order encompass some Tyler procedure, but it comes out the same essentially, you will have to, and there may be litigation involved, figure out what percentage goes to whom. Is it a third, is it a half?
Either the city would, or the city would file some action with an interpleader action and ask that they not have to be the ones to take on that burden. But if we had to, we would. I can tell you that Judge McSweeney noted in the 2014 decision, which was affirmed by this court, it's in the appendix, that Mr. Driscoll himself had testified during the probate case that he was a one-third owner, that he had filed a bankruptcy case in 2004, attesting under the pains and penalties of perjury that he was a one-third owner. There's representations made throughout our case in the probate cases of being a one-third owner. So I don't think it's much in dispute, but if somebody wished to litigate that and hold the city accountable, we would go and we would do that. I mean, I think the court could also take judicial notice of the fact that the Driscolls did file for bankruptcy. There has been a stay in this particular case, so there's issues that are.
But that has been lifted with respect to this?
It's been lifted in
Okay.
terms of a stay with respect to this case, yes.
Yeah, okay.
So I think there are numerous ways to go and deal with Tyler. The city is not in any way, even when we did our appellee brief, we knew Tyler was going to go and be argued, didn't know how it was going to go and be decided, but we went and stated in our brief, whatever the law that would come out of that, we would go and comply. And Tyler says you have to account and you have to go and pay the surplus to the former owner. Tyler recognizes City of New York versus Nelson, which was a case where the city made the surplus available. It just had two procedural requirements. Number one, it required that the former owner, had appeared in the underlying court case and claimed the right to redeem and claimed the surplus. And the second is that they had a time limit upon giving notice that there was the surplus available to claim it, and it was 20 days. And in the Nelson case, the U.S. Supreme Court had affirmed that. That issue came up both in briefing and argument, and was written in the decision, and Nelson was gone and not in any way affected by the Tyler case. So it's clear to us that what Tyler represents is that it's a taking violation. It would be a constitutional tort if a municipality foreclosed on a property, did not provide an accounting to the former owner, and did not remit the surplus to the former.
Do you understand the right of redemption to give the full title to the entire property to whoever redeems it? Or just?
No.
Okay, so what, because you just said that the person with the right of redemption has some rights.
The former owner is the one. With
Okay,
the
but
rights.
if we have two owners and one doesn't want to redeem and one does, and one in fact gets an order allowing redemption, as happened here, if the Driscolls had paid during the 60-day period, the right of redemption period Joseph was given, Joseph would not own the full property, he would continue to own his one-third share.
Correct. So when the right of redemption is exercised, all that has happened is the lien is erased.
Right.
The taking is redeemed. It goes right back to where it was
Okay.
the day before the taking was there. You don't gain any title by doing it. There is provisions under Chapter 60 of a lien of a co-tenant, so they could claim rights and claim monetary redress with respect to that, but they don't gain one bit of ownership interest or lose one bit of ownership by the fact that the taking is.
Yeah, I understand.
Does it make any difference, the fact that the estate has kind of, as you said, washed their hands of this?
I think it's very significant because it's why Judge Smyth issued the 60-day finding and why Judge Smyth denied the motion to enlarge. There was no vehicle, there was no way to go and redeem the property. They did not have the cash.
Of course, now,
Oh, no, but prior to
Dan, but now under Tyler, and I don't know who's lending money on the basis of this, but for the rights to the extra money as collateral, that's going to be sold, maybe you could borrow.
Your Honor, the representation made by Mr. Driscoll in the own court case was that they could not redeem. They couldn't exercise the right of redemption because of the estate's action and bar with them. And what's important for Mr. and Mrs. Driscoll here is that they actively resisted for 10-plus years a partition case which sought the sale of the property, pay the back taxes, and split up the proceeds. So on one hand, they're actively impeding the very thing that would have salvaged whatever equity they had in that property. But they themselves represented in their own filings in the underlying court case that their co-owner's refusal to agree with them to mortgage the property, their refusal to sell the property, precluded anything from happening. And that's why their argument was stay the land court case, extend the redemption period until this endless probate partition case gets completed someday down the road. And right now it's in year 18, 19 of being pending in the probate court. And Judge Smyth said no. And we believe that 13-plus years of having that opportunity to redeem was more than sufficient. The fact that the Driscolls had personal impediments to achieving a redemption because of their legal disputes and disagreements with the family members is not a denial of due process.
They say that they're entitled to an evidentiary hearing on how much they've paid, and they purport to have, although I didn't see them in the appendix, canceled checks and so on. And you have a chart that purports to cover those canceled checks, but I don't know how I'm supposed to figure out if it does or not, or even if it's true or not. Do you see what I mean?
I do, Your Honor. And so I think what's important here is the record. And so what happened in the underlying case is that the Driscolls continued to make these arguments, supported with the canceled checks and the records, that went outside the parameters of what was the subject of this tax title case. Chief Justice Piper issued a ruling in 2012, followed by Justice Smyth over and over again, that we were talking about a defined period, fiscal 8 taxes through, at that time, I believe it was fiscal 21. So show me any taxes assessed from this starting point to this date and any payments in between. And if there's anything there that conflicts with what the city is representing, absolutely, we're going to have a hearing about it, or we're going to go and resolve it. Despite 100-plus pages and repeating the same arguments over and over again, there was nothing within those parameters for there to hold an evidentiary hearing. And then even after the court entered the finding, they tried again with a motion for reconsideration. And the judge said, you want to file an affidavit and try again? Okay. And then we went and did this chart, something that we weren't required to do, but we wanted to have evidence for the appellate record later that every single dollar or charge for C&D that was from this starting point to this end point was accounted for and shown in the city's records. And there was nothing outside of that.
Was that in an affidavit or attached to an affidavit? I'm just wondering.
Pleading, I don't recall if it was attached to an affidavit or not. Your Honor, it was a supplemental appendix, page 127, I believe. But we feel this was very carefully considered by Judge Smyth, both the first time and the second time. The request for an evidentiary hearing was thrown over and over and over again, and he kept probing what would we go and be taking testimony in and going and analyzing. And at no point could we go in and frame and identify a particular transaction, a particular payment. It was just throwing the same old stuff against the wall for the purposes of engaging in this litigation war of attrition that would never, ever, ever end. And, this has been exceedingly long, exceedingly burdensome to the city, and the city has simply asked for finality. And they're doing a lot of things post-judgment. We have the bankruptcy case, there still has to be an eviction case, there's still likely more appeals. There's a long way still to go for the city to get its tax money. And it's hopeful that it is moving towards that goal.
I have one more.
Sure.
Ms. Driscoll says that they paid the quite small taxes on the E parcel. You just factually disagree with that?
Yes, that's disputed in the record. There's a reference to a payment. A, it's in the chart. B, it's also Ms. Driscoll's letter with a letter back from the collector's office, and my office is in the appendix. But the parcel E, once the taking was done and the foreclosure case was filed, the only one who had a right to redeem was Truetta Corporation. And that past payment and all that was far before that.
There were later assessed taxes that were not paid, or you didn't accept the payment because only Truella could redeem?
No, Ms. Driscoll had made a payment in the past. It was accepted. It was applied. My point being is that once it became clear that Truetta was the owner and that Mr. and Mrs. Driscoll did not have standing, two things happened. Number one, there was no payments on parcel E, so there weren't any payments that were refused, I don't believe. But number two, even if they had been tendered, they would have been refused. But
So you
that's-
could foreclose on a property, that part I still don't understand.
But basically, only the owner. I think what you're saying is that only the owner
Only the
can pay
owner,
the
the
taxes
mortgagee,
and have
or-
the
I don't
right of redemption.
understand what the interest of the city is in who pays the taxes. The city's interest is in getting its money.
Well, that's part of it, Your Honor, but the city's also stuck, which it's stuck right now, with a disaster of a property and situation.
That's different. This hasn't been condemned, or?
Well, because it's a fractured title. When you have when we have fractured title to property, and we can't seize the equity, we can't redeem it, you can't pass it on to the next generation, messes come about. And whether it's code and code compliance, or it's major title issues and taxes don't get paid later on, there is an interest in a municipality of having cohesion of title, which allows for equity, which allows for lending, which allows for the free transfer of property, which allows for taxes to get paid. A lot of these problems that we see in tax title cases surround that either loss of equity or the inability to access equity based on conventional means. And this is one of them. And having people own property or having people own a portion of a house and not others and can't do anything, that's where we get into trouble. And I think that's part of the story here.
Well, thank you both very much. We appreciate your briefs. We have them. We'll review them again. We appreciate your arguments, and I will take the case under advisement.
Thank you.
Court order.